court in the Lively versus Wayfarer matter just issued an order regarding the birthing video. Let's break it down. Recall that Lively sought sanctions against Heath for failing to produce all video footage related to the birth video that the court purportedly ordered to be turned over at some point. And she's saying that she's alleging now, or she's claiming now, that she was shown an actual birth video, while Heath in his deposition and in his filing says no, and in the complaint that they countersued with said no, it was a picture of after the birth. So there is a dispute about what video was shown, and Lively is saying it doesn't matter. The court ordered all of these requests to be produced, to be handed over, and they didn't hand over everything. So they should be sanctioned and should have to not be able to even defend themselves with respect to this issue at trial or MSJs. They are not able to offer any evidence. That is the type of draconian sanctions that she requested. The court did what I thought it would do, which is say, okay, hand over the videos, but did not provide those extreme sanctions that Lively wanted. Basically, what the court is saying is that the issue of whether or not this is the video that she was shown or not is not being decided right now. The court is only looking at the specific requests that were moved to compel back in the day, and says that at that point, Heath didn't object to whether or not it was within the bounds of that request. Because they didn't oppose that, it was technically ordered to be handed over, then it's technically ordered for him to be handing over now. That these other videos fall within the definition of concerning, as written in the request. Because it falls within the definition of that request that was not opposed, that he should have handed it over. Let me be abundantly clear that this is not one of those defendant is hiding something type situations. This falls into one side is interpreting a request one way, the other side is interpreting a request in another way. And with Heath not opposing the motion to compel, they presumably thought that they were turning over exactly what they needed to do, which was the video that they admitted that they showed. The judge looked at this and said, well, technically it falls within this greater category, and, you could have opposed back then and said, so I'm just going to say that it falls within it. He's been taking an expansive view of discovery, so no surprise there that he's saying just turn it over. However, he goes a step further, and I think this is really important. He says, the materials at issue are no doubt extremely sensitive and deeply personal. They therefore fall within the category of materials in litigation that, while potentially discoverable, are still subject to strict confidentiality provisions, preventing public disclosure. And given their sensitivity, it is highly unlikely that their disclosure could ever be warranted. This is extremely important. The court is saying, fine, if you need to see these other videos to prove that you saw another video, that's what discovery is for, then fine, you can see the other videos, but these are not going to see the light of day. And if they do, if there is any video that gets leaked to the press or to the public somehow after this, that could be a very, very, very bad thing for Lively's lawyers. Like disbarment. Like truly it would be the worst thing. Because the court didn't mince its words here. It was like, there is no place for this to see the light of day. Next, the court addresses this request that Heath be prevented from offering evidence on the topic of showing the birth video or any portion thereof. And he just flat out says that request is denied. The court goes through a number of factors under the federal rules that a court weighs when considering what type of sanctions to impose upon someone when it finds that it is in technical violation of a court order. Those factors include the willfulness of noncompliance of the party, the reason for the noncompliance, the efficacy of lesser sanctions in achieving the results intended, the duration of the period of noncompliance, and whether the noncompliant party was ever warned of failure to comply. And the court says weighing all these factors goes against the relief that Lively requests. I think this first factor is actually quite important because it says that Heath argued that his failure to provide the footage was not willful because of the best reading of the court order. Their argument was that we understood the court order to say turn over birthing video that he agreed or admitted to showing. The court says, well, we don't agree with your interpretation of that. We think that you should have turned over the bigger universe of videos here, but says that this is not enough of a mistake to be egregious, to be considered willful. And the interpretation, Heath's interpretation, was not so mistaken or unreasonable as to give an inference of willfulness. The reason why I think this analysis here is really important is because it's a window into how we're going to see the judge rule on things like Rule 11, which turn on factors similar to this about willfulness, about mistaken understanding, about everything that we saw with what we're going to see with respect to this new filing that the Lively team filed on Friday about Sarowitz and Abel and the potential or alleged willfulness of wrongdoing that they're being accused of. What I'm trying to say is that the judge is going to give the benefit of the doubt to the other person, to the accused person. For example, an allegation that Sarowitz or Abel willfully sued Lively to retaliate against her, that doesn't seem to be, based off of what I'm reading here, an inference that he is going to be willing to make. Just because the Wayfarer's claims were dismissed isn't going to be enough to prove that these parties filed their lawsuit just to harass Lively. The last factor, and the most important in the court's view, is that lesser sanctions are available and they are sufficient. Lesser sanctions are produce those documents and pay for the costs incurred for Lively having to file this particular request. So, I don't know, $10,000, $7,000, whatever the cost was for Gottlieb to write that letter, that would be the cost, that would be the amount of sanctions that are issued here. And that is very normal. So if you were to win on these kind of requests, it's very normal to win the amount of money it took for you to make the request. Not the amount of money in the world, but just for this specific request. So then 2 hours? Max 3. I mean, 3 is a lot, but the 2 hours of time for him to write the letter, maybe another hour to review the opposition. So 5 hours of time. I mean, really $10,000 soaking wet. When you're talking about a case where tens of millions of dollars have already likely been spent by both sides, that's a drop in the bucket. Ultimately, Lively, it gets to see all the videos. And frankly, I think it does feel like it was all designed to insult and embarrass Heath. And they accomplished that because now he has to turn over further intimate videos implicating his wife. And yes, I know there are some that say, well, he should have never brought it into the workplace. But he is admitting to what he showed and he produced it. And now he's being forced to dig into the vault and show everything else because there's a dispute as to what Lively saw. And at the end of the day, they're going to need to prove severe or pervasive. And I don't think this is going to prove that.